Hello, everybody, and thank you for joining us for today's webinar. I wish someone told me sooner, an introduction to advanced medical directives and powers of attorney, presented by Seton Hall's Alumni Office. My name is Sean, and I'll be moderating today's session. Our presenters for today are Joseph Hallock and Peter Cammarota, and I'll let them introduce themselves further in just a little bit. We have a couple reminders and notes for our next hour together. So you can ask questions throughout the webinar, and we do encourage that you ask questions because it does help facilitate our conversation. You can ask a question by using the question feature on your screen and typing in your question. On a side note, the slides and audio might have a 1 or 2 second delay, so if you guys could be patient, we'd really appreciate it. If you need any sort of assistance during this presentation, and if you're having any sort of technical difficulties, there's a private chat, and I'll reach out to you if you raise your hand. So click the raise your hand feature, and I will reach out to you in the private chat, and we can figure out what the issue is. So without further ado, I'd like to hand it over to Joseph and Peter. Guys, take it away.
Thank you, Sean. Good afternoon and welcome to everyone. It's a pleasure being here, and I hope everyone is doing well. I'm Joe Halleck, and as for my background, I graduated from Seton Hall University in 1966, majoring in accounting, and received an MBA degree from Fairleigh Dickinson University, my law degree from Seton Hall Law School, and a Master of Laws from NYU. I'm admitted to the New Jersey and Florida bars, and I'm also a fellow of the American College of Trust and Estate Counsel, and I'm of counsel to the Scura law firm here in Wayne. We're all familiar with the term living will as a document which specifies what action should be taken if someone becomes unable to make medical treatment decisions for himself. I've already mishandled this because I think, Peter, you would like to say hello to everybody.
Well, I'll introduce myself at the power of attorney.
Okay. Okay, sorry.
That's okay.
Today, all 50 states recognize living wills as legal documents, but it wasn't until 1976 when California became the first state to legally authorize living wills. Ultimately, the courts sanctioned living wills. And in 1992, New Jersey enacted the Advanced Directives for Healthcare Act. An advanced directive, commonly referred to as a living will, is one of the 3 basic documents that most people should have, and that includes a last will and testament and a power of attorney. The living will is probably the most misunderstood of the 3 documents. So the first question is, what is an advanced directive for healthcare? Well, the Act defines an advanced directive as a writing executed in accordance with the requirements of the Healthcare Act, and it may include either a proxy directive or an instruction directive, or both. My standard living will includes a proxy directive, an instruction directive, and a HIPAA release provision, and we'll talk about that later. So let's address the proxy directive first. We know that a proxy is a stand-in for someone to make decisions on another's behalf. In the living will situation, proxy means to authorize someone to make healthcare decisions for someone who's unable to do so himself. So a proxy directive is a writing by an individual referred to as the declarant. We'll call him John Smith, which designates someone referred to as a healthcare representative, and we'll call her Jane Smith, his daughter, authorizing Jane to make healthcare decisions for her father in the event he subsequently lacks decision-making capacity. That's the ability to understand available healthcare decisions, their benefits and risks, and alternatives to any proposed healthcare choices. The declarant must be a competent adult, which in New Jersey is age 18 or older, and executes the proxy directive in accordance with the Healthcare Act, as we'll discuss later. Typically, John Smith would state in his living will that if he's unable to understand the nature and consequences of healthcare decisions, he designates his daughter as his healthcare representative to make all healthcare decisions on his behalf. Let's address the instruction directive now. Remember, the Healthcare Act includes either a proxy directive or an instruction directive, or both. The Healthcare Act defines an instruction directive as a writing which provides instructions regarding the declarant's wishes for healthcare should he subsequently lack decision-making capacity. So John Smith's instruction directive would state how he wishes to be treated if he becomes incapable of making healthcare decisions for himself. It's actually a provisional document because the Healthcare Act states that an advance directive becomes operative only when it's given to the attending physician or to the healthcare institution, and it's determined that the patient lacks capacity to make a healthcare decision. Until then, it has no effect. So if Mr. Smith's living will can't be found, Jane won't be able to make healthcare decisions for her father. That's why we have our clients sign several copies of the living will, although a photocopy of the living will is as good as an original. I generally have clients sign enough living wills for the client, each healthcare representative, and my file. But again, I'll never have had a doctor or hospital require an original of the living will in lieu of the copy. Now, the definition of a healthcare decision is significant. It means a decision to accept or refuse any treatment or procedure used to diagnose, treat, or care for a patient's physical or mental condition, including life-sustaining treatment, or to accept or refuse any services of a particular doctor or other healthcare professional. If John Smith doesn't have decision-making capacity with reference to his healthcare, then the healthcare representative may act on his behalf. I say may because the Act has additional requirements for a proxy directive to become effective. Let's talk about the execution of an advance directive, which, as I stated earlier, covers both a proxy directive, naming a healthcare representative, and an instruction directive, stating the declarant's wishes as to his healthcare in the event he becomes unable to make decisions for himself. The Healthcare Act provides that the living will must either be signed and dated by the declarant or by someone at his direction. The signing must be in the presence of two adult witnesses, neither of whom is the healthcare representative. And the witnesses must attest that the declarant is of sound mind and free from duress and undue influence. So Jane Smith should not witness her father's signing, as she is designated as his healthcare representative. Alternatively, instead of two witnesses, the living will can be executed and acknowledged by an individual authorized to take oaths, such as a notary or an attorney. The advance directive can also be supplemented by a video or audio tape recording, but that doesn't replace the signing procedure that we just mentioned. Typically, the designated healthcare representative would videotape the execution of the living will if he believes that someone might challenge the declarant's competency. It's not generally done, but in appropriate circumstances, it's a good practice. Unlike the power of attorney, which may have two or more agents acting together, and Peter will cover that later, or a will that may name multiple executors or trustees, Mr. Smith can only designate one health care representative at a time. And that's probably a good thing. John Smith may wish to name all his children to serve together, but that may be problematic if they all aren't available, or worse, if they don't agree on their father's treatment. The declarant may designate one or more individuals as alternate healthcare representatives, listed in order of priority. John Smith could name his daughter as his healthcare representative and include a provision stating, for example, in the event Jane Smith is unavailable, unable, or unwilling to serve for any reason, as certified by my son Richard Smith, then I designate Richard Smith as my healthcare representative. We then include language describing the procedure. Such certification shall be in a document signed by Richard, stating that Jane is unavailable, unable, or unwilling to serve. Such certification shall be accepted without question by anyone to whom he presents this proxy directive and certification. Mr. Smith can go further and name additional healthcare representatives by using similar language. For example, if both Jane and Richard are unavailable, unable, or unwilling to serve, I designate my niece, Mary Doe, and so on. The typical practice is to name one or two alternates, but the Healthcare Act doesn't limit the number of alternate healthcare representatives. Some clients wish to name all of their children or siblings or others, so as not to offend anyone. But again, naming healthcare representatives in order of priority rather than co-representatives makes sense. Being a healthcare representative is an awesome responsibility. So Mr. Smith may lessen James' burden, or if he feels that others could be helpful in sharing their advice, he could direct Jane to consult with the named alternates or anyone else he wants to include with respect to the decision-making process. The language I typically use is, notwithstanding that I have named my daughter Jane as my primary health representative, I direct that she consult with my son Richard in any healthcare decisions that might have to be made on my behalf. Nonetheless, Jane would make the final decision, even if it's contrary to the others' opinions who she consulted. The Healthcare Act states that adults have the fundamental right to control decisions about their own health care unless they lack the mental ability to do so. If that happens, the advance directive becomes effective when it's given to the attending physician or to the healthcare institution, and the attending physician determines that the patient lacks the ability to make a particular healthcare decision. A second doctor must confirm that their determination, unless it's clearly apparent and the attending physician and the healthcare representative agree that confirmation is unnecessary. If that's the case, then life-sustaining treatment may be withheld or withdrawn from the patient in any one or more of the following four circumstances. First, when the life-sustaining treatment is experimental or is likely to be ineffective in prolonging life, or is likely to merely prolong an imminent dying process. No one should be forced to undergo experimental treatment with a small chance of preserving his life. Second, when the patient is permanently unconscious, as determined by the attending physician and confirmed by a second doctor. Third, when the patient is in a terminal condition, again as determined by the attending physician and confirmed by a second doctor. Or fourth, when the patient has a serious, irreversible illness or condition, and the likely risks and burdens associated with the medical treatment may reasonably be judged to outweigh the likely benefits of the treatment. These four conditions are the only ones that allow life-sustaining treatments to be withheld or withdrawn, but they're broad enough to encompass virtually any serious condition Mr. Smith might encounter. Definitions pertaining to the decision to forego life-sustaining treatment include the following, and please bear with me. Life-sustaining treatment means the use of any medical device or procedure, artificially provided fluids and nutrition, drugs, surgery, or therapy that uses mechanical or other artificial means to sustain, restore, or supplant a vital bodily function, and thereby increase the expected lifespan of a patient. That's a life-sustaining treatment. Permanently unconscious means a medical condition that has been diagnosed in accordance with currently accepted medical standards and with reasonable medical certainty as total and irreversible loss of consciousness and capacity for interaction with the environment. It includes a persistent vegetative state and an irreversible coma. And terminal condition means the terminal stage of an irreversibly fatal illness, disease, or condition. A determination of a specific life expectancy is not required as a precondition for a diagnosis of a terminal condition, but a prognosis of a life expectancy of 6 months or less, with or without life-sustaining treatment, is considered a terminal condition. An advance directive is not cast in stone. Mr. Smith can revoke his living will at any time by notifying his healthcare representative or healthcare professional or a reliable witness, orally or in writing, or by any other act which shows an intent to revoke the document, such as tearing it up. The execution of a new advance directive would also revoke the prior document. The designation of the declarant's spouse as a healthcare representative is automatically revoked upon their divorce or legal separation, and similarly for the declarant and his or her domestic partner or a partner in a civil union. The better way is to have a new living will naming people other than the former spouse, just as they should make a new will and power of attorney, change life insurance and IRA beneficiaries, and any other documents where the ex-spouse is named. So generally, John Smith's living will is valid until he revokes it, but I recommend that he review it periodically to see if changes are appropriate. He may change the healthcare representative or alternates, or he may rethink his feelings as to his healthcare decisions. If he relocates to another state, an advance directive would usually be valid there as long as it was executed either in compliance with New Jersey law or that of the new state. But I always recommend that he contact an attorney in the new state to discuss not only the living will, but also his last will and testament, power of attorney, and other estate and tax planning documents. I said earlier that the typical living will that I suggest has three components: a proxy directive, that's the designation of a healthcare representative and alternates, an instruction directive addressing healthcare decisions, and a HIPAA release authority. HIPAA is the acronym for the Health Insurance Portability and Accountability Act that addresses access to an individual's healthcare information. Mr. Smith can authorize his healthcare representative to obtain his health information, documents, and medical records from doctors, hospitals, and other healthcare professionals. The inclusion of a HIPAA provision in the living will would give Jane access to medical information, generally stepping into her father's shoes if he became incapacitated. Since an advance directive isn't effective until Mr. Smith is determined to lack the capacity to make particular healthcare decisions, the HIPAA release section should include a statement to the effect that Jane's authority to receive health information takes effect immediately upon her father's executing the advance directive, even though he's not incapacitated. In my experience, no one would deny Jane her father's medical records, even if he hasn't been declared incapacitated, as long as he includes a HIPAA release provision in his living will. Mr. Smith may include a variety of provisions in his living will as long as it doesn't violate the Health Care Act. Although the typical client is concerned with physical conditions, I recently had a client who had serious mental problems over the years. His mental disorder was his major concern and wanted to emphasize it in his living will. So I included a provision authorizing his wife, naming as his healthcare representative, to initiate and extend psychiatric treatment, consent to his being institutionalized, determine in consultation with his doctors the appropriate medication to be administered to him, and generally to make any decisions we could have made with respect to his mental health treatment. Another client had an only child who lived halfway across the world. I included a provision in the instruction directive portion of her living will, authorizing her doctor to provide life-sustaining treatment to keep her alive in order to provide sufficient time so her daughter could be with her, as she anticipated that she may very well be out of the country when such life-sustaining treatment would otherwise be withheld. While most clients want to have life-sustaining treatments withheld or withdrawn, others prefer a provision to the effect that it is my intention, and I hereby direct, that if I should have a terminal condition or I'm permanently unconscious, I wish all life-sustaining treatments be provided to me and not be withheld or withdrawn from me. She was a young person who would never lose hope that she might recover if she ever became incapacitated. Other clients wish to have a period of time, such as a month or two, during which aggressive life-sustaining treatment is to be given, after which the condition would be evaluated, and if there were no improvements, then all treatment would be terminated. Again, a declarant may include a variety of provisions in their living will, as long as it doesn't violate the Health Care Act. If anyone has any questions at this point, I'd be happy to try to answer them.
Joe, yes, actually, we did just get a question. So the question is, where should I store my living will and advanced directives so that my family can find it easily?
Well, as I mentioned at one section, they should make a number of living wills to cover for himself and his possession, a copy for each healthcare representative named, and alternates, my client, my files in my law office as well. You can make any number of copies, and they can provide that to the doctor or the treating physician, or the hospital, or the nursing home. So it's better to spread them around so everybody has it, so they know what the declarant's wishes are.
So essentially, they should give them to the people that would be within those directives or the will, correct?
Yes, that's correct.
Okay. All right. Well, that was the only question we had so far. Don't worry. Please keep asking more questions. We'll have another section at the end of Peter's talk for more questions to be answered.
Am I ready to go?
You're ready to go, Peter.
So my name is Pietro Cammarota. I go by Peter. It's a lot easier for people. I am a graduate of Seton Hall Law School. I graduated in 1998. I am admitted to both the New Jersey and New York bars. However, I focus my practice in New Jersey more. I'm also a member of the National Academy of Elder Law Attorneys. And that's an organization of attorneys that deal with elder law matters. I am a partner with the law firm Scura, Whitfield, Hire, Stevens, and Cammarota, and I head up the Trust, Estate, and Elder Law department. And I limit my practice to those areas of the law as well. What I'm here to talk to you about is going to be powers of attorney. And a power of attorney is a document in which you appoint somebody to do things for you on your behalf. Okay? Without a document such as a power of attorney, no one has that authority. And I want to start with a common scenario that I often see in my practice, just to illustrate how a power of attorney can be useful. So in this fact pattern, there's typically a husband and wife, and they have 2 adult children. In this case, the husband and wife are in their 80s, and the husband suffers a serious stroke that leaves him both physically and mentally incapacitated. And as a result, he's no longer able to handle any of his legal or financial affairs. Okay. Now, in terms of assets, let's say they have a home that they own together as husband and wife. They have various bank and brokerage accounts, mostly in joint names, but let's say the husband has a few accounts in his name alone. And the cars are in the husband's name. Okay. In this case, if the husband and wife do not have a power of attorney, that means that the wife cannot handle any of the husband's affairs. She does not have access to those bank accounts that are in his name alone. She cannot do anything with titles to the car. And if there was some planning that might have been appropriate, such as maybe putting the house in the wife's name alone in order to have the husband qualify for Medicaid, she can't do that. And the point of this is that just because someone may be married or maybe some kind of close familial relationship, that in and of itself does not grant authority to handle someone else's financial or legal affairs. Right. So that's where power of attorney can kind of come in. So what a power of attorney is a written document in which one person, who's called a principal, appoints somebody else, another person or a banking institution, to be his or her attorney in fact. And that's just another way of saying an agent for them. The document has to be in writing. It's got to be signed by the principal, and that signature has to be notarized. Typically, when in the context of estate planning, powers of attorney are going to be what's called durable. Durable power of attorney is a power of attorney that says that it is not affected by the principal's later incapacity or from the passage of time. And that's typically the power of attorney that we have in estate planning context. There are other powers of attorney. If it doesn't have that language that makes it durable, then that power of attorney can lose effect if the principal becomes incapacitated. Now, there are different kinds of powers of attorney that can be used. Some are going to be effective immediately. And what that means is as soon as the principal executes that power of attorney, the agent under that power of attorney has authority to act on that principal's behalf. You can also have a power of attorney where the authority does not come into effect until the happening of another event. of a certain event, and that is called a springing power of attorney. Once that event, typically, the principal is declared mentally incapacitated or was determined not to be able to handle his or her financial or legal affairs, then that power of attorney will spring into effect. And the reason why one would go with one or the other is usually an issue of control. Some people figure that they'd rather be in control of their assets or their affairs as long as they're able to do that. And then if they're not able to do it, then that power of attorney would spring into effect. And that gives comfort to some people. That does add a little bit of a burden, because now in order to use that power of attorney, the agent has to prove that that condition happened, such as having a letter from a doctor or two that says that, well, so-and-so can no longer handle their financial affairs. So depending on what your comfort level is, you can choose one of those powers of attorney. I typically recommend one that's effective immediately, only because that's a lot easier to use. Now, another category of power of attorney is whether they're going to be what's called general or limited powers of attorney. So a general power of attorney is a power of attorney in which you grant basically the power and authority to do anything that you can do upon your agent. Typically, it's going to be a very broad language, but they are strictly construed. What that means is that whatever language you put into that power of attorney, it's going to be limited to that language. So typically, you're going to make references to banking authority and things of that nature. And there's other authorities that are often not included in general powers of attorney is the authority to engage in gifting. And gifting in this context is typically going to be for either estate planning purposes, where you're trying to reduce or eliminate some sort of death tax, or and more commonly where I see it is where you're trying to preserve assets from long-term care costs, where there may be some gifting that can be done to preserve assets. And to use our example from earlier, under a power of attorney, had the husband and wife had a power of attorney that had gifting authority, the wife could have gifted the husband's interest in the home to herself, and that could have offered some protection against that home from long-term care and Medicaid costs. Limited powers of attorney are typically not used in the estate planning context because they're typically done for a specific purpose, and they're limited to that purpose. A common example is if you want someone to handle the sale of your home, you may give a limited power of attorney to a child or to a spouse to be able to represent you at that closing. And then once that closing is done, then the purpose of that power of attorney is satisfied and it's no longer effective. But again, in the context of estate planning, typically we're talking about general durable powers of attorney. And typically you want to have as much authority as possible to ensure that if that agent has to step in, they have the ability and the flexibility to achieve what needs to be achieved. Let's talk a little bit about the attorney in fact or the agent. That's an important decision. Every so often I get somebody who asks whether the attorney in fact has to be an attorney, and that's not the case. An attorney in fact is just technical language used in the New Jersey statute that refers to really what was commonly known as an agent. That's someone that you appoint to be able to handle your affairs. Typically, a person would pick a close family member to be their agent. Some things to think about, though, are going to be because a power of attorney typically deals with financial and legal affairs, and depending on how much assistance they have to give, can be in essence managing someone's life in terms of paying bills and budgeting and things of that nature. Typically, you're going to want to have somebody who's going to have some kind of experience or proficiency in handling financial matters. It doesn't have to be an accountant or an attorney or a financial advisor. You can pick more than one attorney in fact or agent at a time. But you have to designate how they ought to serve. Because if you pick, say, both of your kids and you say nothing else, then the statute in New Jersey requires that they act together, which means that if they're going to pay your PSE&G bill, then both of them have to sign that check, which can be a pain. So if you want them to be able to act independently of each other, then you have to specifically say that in the power of attorney. Also, now, why would you pick independent or joint? And again, it depends on who you pick as your agent and what are your concerns. Typically, when I have clients who want to have multiple attorneys, in fact, act jointly, it's because they want them to watch each other. Maybe there might be some trust issues, or maybe they're concerned about someone taking liberties. So they want to have another agent, another child, who would work with that person and prevent any kind of mistakes, so to speak. But again, that adds a little bit of burden to being able to efficiently carry out their obligations. You can also pick successor attorneys, in fact. And what that means is you may want to pick a spouse first, and as long as that spouse is able to serve, then that spouse is going to be your attorney, in fact. But if that spouse cannot do that anymore, maybe because the person passed away or they're incapacitated themselves, then you can have a backup, a successor, or an alternate take over at that point. Once an attorney, in fact, or agent acts under a power of attorney, then they have a fiduciary obligation to the principal. Again, it doesn't mean that they can do whatever they want under the power of attorney. That agent has to act in the best interest of that principal. While the principal is capacitated, or has capacity, I should say, then that agent has to act within the scope or direction of the principal. If the principal is incapacitated and is unable to supervise their agent, then it can act in a best interest capacity. But again, a power of attorney doesn't take away your authority to handle your own affairs. It just appoints someone to be able to assist when you want to be assisted. Now I want to talk a little bit about. Well, actually, let me continue with the agent. What the fiduciary capacity means is that the agent is handling someone else's asset and has to take care of that. And what that means is that that agent has to keep accurate records of what they do on behalf of that principal, and can be required to account to that principal. What that means is basically explain what they did while they were acting under the power of attorney. Again, the idea is that they're acting on behalf of someone else, and they have to be careful of what they do and make sure they act for the best interest of that principal. Next, I kind of want to go into the third-party reliance. So third-party reliance on a power of attorney refers generally to, when you give the power of attorney document to somebody, like a bank, what are the rules there? So the way New Jersey law works is that as long as someone is presented with a power of attorney, and they are protected from liability so long as they honor it. But what that means is, if I present a power of attorney to a bank, they are permitted to, do what the agent tells them to do without fear of being sued by the principal. As long as there's a good faith belief that that power of attorney is valid and it has not been revoked, then that bank is shielded from liability. Now, the only way, what a bank can do, typically with the power of attorney, is they can ask for a certification to ensure that that power of attorney is still valid. And what that means is that they can ask whether or not the principal passed away, because once the principal passes away, that power of attorney ceases to be effective. Or if that principal revoked the power of attorney, or in certain cases, if that principal was incapacitated. So typically, what a bank will say is when they're presented with a power of attorney, is they'll ask that the agent certify to these three things, and that's permitted. Next thing I want to talk about is going to be compensation for your attorney, in fact. So what New Jersey law says is that an attorney, in fact, is not entitled to be paid for their time and services acting as an agent under a power of attorney, unless the power of attorney itself permits it, unless there's a separate agreement that permits it, or there's a court order that permits it. And because when someone acting under as an agent under a power of attorney, it can be a lot of work, you should consider whether you want to pay that person to do it. Typically, what you should be is you should be as specific as possible in that, meaning what's the basis for that compensation, when should they be compensated, and how should they be compensated. Typically, in our form of power of attorney, what we do is we say that that attorney, in fact, or agent can be compensated based on whatever is the normal rate for whatever services are being rendered. So if that agent is acting as a bookkeeper, then whatever a bookkeeper gets on an hourly rate, that would be what they would be compensated for. But again, it's always a good idea to think about doing that because it can be a very onerous obligation for someone to act as an attorney in fact. Next, I want to talk about revocation of a power of attorney. So similar to the living will, a power of attorney is not written in stone, and the principal can revoke it at any time. And there's different ways of revoking it. The first is to destroy all the original powers of attorney. That's simply just ripping it up. Another way of doing it is to make a statement that the power of attorney is revoked. So sometimes in the power of attorney that we prepare, they'll have a statement that I hereby revoke all prior powers of attorney. The death of the principal also revokes the power of attorney. But a key part of all these is, in addition to the act of revoking the power of attorney, there has to be notice given. And that notice has to be given to the agents and also to the third parties or the anticipated third parties who may have a copy of that power of attorney. That way they are put on notice that that power of attorney is no longer effective. And that's basically with the powers of attorney. I mean, it is one of the most important documents you can have. Again, without a document like a power of attorney or an advanced directive, no one has the authority to be able to handle your affairs, whether they be medical, personal, legal, or financial, on your behalf without that authority, which is what the key takeaway should be from this presentation. And if anyone has any questions, we'll be happy to take them.
All right, great. So we had a couple questions come in. So the first one says, can any of these documents that you guys have mentioned, both Joe and Peter, can they be saved in digital medical records? Or I guess maybe just, can they be saved digitally in general?
Well, if I can answer this, the answer is it depends. Because with the power of attorney, typically photocopies are permitted. There are certain circumstances where an original power of attorney is required. That typically involves any kind of transfer of real estate, because the original power of attorney has to be recorded with the original deed when you want to convey property or transfer property with the power of attorney. Third parties, again, such as banks, are allowed to make photocopies of powers of attorney. Sometimes they want to see them, the original, but they're permitted to rely on a photocopy or a document that's certified to be a true copy of a power of attorney. So, if you have an electronic copy of the power of attorney that's signed, so what I would think that means is going to be a scanned copy of an executed power of attorney that can be presented. You may get a question from the third party that says, well, we'd like to see the original. And once they see that there is an original, then they can rely on that photocopy. But other than that, you typically can't use an electronic copy in and of itself, other than in that regard.
Okay. And Joe, what about the living will and the medical directives? Is that something that's able to be saved in someone's digital medical records?
Yes, it is. And again, it has to be executed consistent with the healthcare directive statute. But you can provide a photocopy of it or a digital method. Remember, I graduated in 1966, so I'm not conversant with this digital stuff. But yes, you could transport the living will by any means. It doesn't have to see the original. I've never had a situation where a patient was not able to use his living will because they don't have the executed original.
Okay. All right, great. All right, so we'll move on to the next question. What happens if your assets are in co-ownership?
So in the example that the fact pattern that I gave earlier, if you have assets that are in joint ownership, that typically means that each owner has the right to it. And this is where you get into the and or type of ownership. If it's an or, that means, in my example, both the husband and wife have full access to whatever assets are in that account. If it's an and, that typically means that both the owners have to withdraw the money or write a check. I don't see those frequently at all. But in the fact pattern that I had, or I presented earlier, the wife could use the assets in those joint bank accounts or financial accounts to be able to pay for the husband's care. Where she would not have authority would be the accounts that were in the husband's name alone. And that's where the limitation is. But as long as there's joint assets, then whoever's an owner on that account has access to that account.
Okay. All right, perfect. All right, so the next question we have is, does the POA have to be in effect in the state where the individual is living?
No. So each state honors the laws of all the other states. So as long as the power of attorney is executed properly within the state where that person resided, then typically the other states will honor that. However, then I run into a situation where a person you may be dealing in a different state may not know that. So, for example, if again, the formalities in New Jersey to execute a power of attorney is that it has to be in writing, it's got to be signed by the principal, and that signature has to be notarized. If you go to a state such as California, or I believe maybe New York, there may be witness requirements. Now, it'd be unreasonable to think that maybe a bank teller in California or New York wouldn't know that New Jersey does not require witnesses, and you may run into that that type of a glitch. But typically, whatever documents you do in New Jersey will be effective in whatever state you are in. If you are doing a specific transaction in a different state, then you're probably going to want to have a power of attorney that may be tailored to that particular state's requirements. And in that case, say you own property in another state, such as Florida, and you wanted to appoint someone pursuant to a power of attorney to handle that sale on your behalf, it might be easier and more efficient to execute a limited power of attorney under Florida law to empower that agent to be able to handle that transaction, instead of the potential confusion if someone in Florida doesn't realize that the New Jersey power of attorney is effective.
All right. All right, our next question is, which is better, POA or directive in terms of access to financial institutions?
Well, what my practice is to include a HIPAA release authority provision in both the power of attorney and the healthcare directive, so that each document says that the HIPAA provision is effective and will not terminate any other HIPAA release authority. So you have it done both ways.
And just to kind of piggyback on that a little bit too, really in the estate planning context, you really should have both. It really can't be one or the other, because they both serve different purposes. The advanced directive is strictly medical, and the power of attorney deals with financial and legal affairs, but then it also crosses into medical a little bit, mostly from a billing perspective. The idea behind these documents is you want to have somebody that you trust and that you select be able to handle your affairs, again, whether it's medical or not, if something happens and you can't. Because if you don't, then the court has to appoint somebody, and that's called a guardianship, which is a very expensive and time-consuming and onerous proceeding, where a judge decides who's going to be that guardian. And if you only have one of those documents, say you only have an advanced directive, and you become incapacitated, well, your healthcare representative under that advanced directive cannot have that, or does not have access to your bank accounts to be able to pay your bills. So again, they each serve a different purpose, and what you should do is have both, because then you cover, not only your medical, but also your financial.
Okay. So our next question says, what if, sorry, excuse me. What if now that one of the parents is ill, what if now that one of the parents is ill, if the children POA has appeared untrustworthy, but the other parent doesn't accept that, this sounds like a very specific case. So I'm going to skip this question, but
Okay.
if you wouldn't mind, if you can see both Joe and Peter have their emails up, I'm sure you guys would love to help this person out. I can also give you their name after this if you want to reach out. It seems like a very specific case.
And that's fine. Please feel free to email us if you have any questions that are more specific toward maybe your situation.
All right. So next question is, in a follow-up to the digital copy question, what if the digital copy is electronically signed? Does it carry the weight of a hard copy original?
Well, that's kind of a very new area in the law, and especially with this COVID-19 pandemic, I think there's probably going to be some change coming because, especially in the area of estate planning and estate and elder law, it's a very old area of the law, and as a result, there's a lot of old conventions, such as a will has to be in writing, signed by a testator, witnessed by two witnesses, and that's a little difficult to do when everyone has to socially distance and a lot of offices are closed. New Jersey and also New Jersey requires that a notary witness in the context of a will witness the signatures. That was changed a little bit, during the stay-at-home executive orders that Governor Murphy issued. They did provide on a temporary basis a little bit of a workaround where you could do that, through a Zoom meeting. But that statute is going to expire once those executive orders are rescinded. So an electronically signed power of attorney and a living will and a will, are not really effective in New Jersey. I have seen situations where in real estate transactions where now lenders want documents to be signed electronically, and if that's okay with them and they set up that procedure for how they want that done, then that's okay on their end. But that's going to be limited to that particular transaction. Whether you can sign a power of attorney electronically and then present it to third parties, there's no basis, at least in New Jersey statute yet, where that is going to be, where they're required to accept that. At this point, you still need originals, at least to be executed or to form the basis of that electronic copy, meaning the original signed, it's scanned, then you can present that scanned copy, to a third party to keep as a copy.
That's the same with the healthcare advanced directive. It has to be signed in the presence of two witnesses or notarized. And once that's done, you can fax it, you can email it, in any other ways. But the original signature has to be not by some computer-generated signature. And that may change in the future, but as it is now, that's the procedure.
Okay, great. So I'm going to move on to the next question. Do decisions made by the agent / power of attorney need to be approved by the principal? What if the agent makes a decision they believe is in the person's best interests, but the principal may disagree?
In this particular question, you have to look at what's the capacity of that principal. Because if the principal has capacity, is not under any kind of a disability, then typically that agent has to act within the scope of what that principal wants. So let's say you have a child who really wants the parent to engage in asset preservation planning or Medicaid planning and thinks the best thing to do is to take the house out of that parent's name. But that parent may not want that. Just because that agent thinks that trying to shield that asset is in that parent's best interest, if that parent does not want that, and that parent has full capacity to be able to make that decision for themselves, then that agent cannot act and do that. That would be acting outside the scope of the authority under that power of attorney, and that agent is subject to liability to that principal. Once that principal loses capacity, if that happens, then a little bit of a different standard comes in now, and then now that agent has to act in the best interest of the principal. You know, in terms of, again, just to keep with that Medicaid example, the terms of the power of attorney are going to be very important in delineating what an agent can and cannot do. So in the context of gifting, the authority to make gifting, let's talk about it in the context of Medicaid. Gifting is not going to be automatically included or authorized in a general power of attorney. So if someone has a general power of attorney, they maybe picked up at Staples, or maybe they went to LegalZoom.com, that general power of attorney may or may not have language that permits gifting. If it does not have language that permits gifting, then that agent can't move that house. If New Jersey also says that if you're going to give gifting and you want your agent to be able to gift to themselves, the power of attorney has to say that as well. So again, the language of the power of attorney is going to have to be tailored to the particular situation of what your concerns may be. Again, kind of circle back to that question, if the principal has capacity and that agent acts in what they think is the best interest for that principal, but that principal does not want that, even if it's unreasonable, as long as that principal has capacity, that agent is not supposed to do that.
All right. So it looks like I got one last question for you guys. So it says here, someone mentioned a 5 wishes advanced directive. Is that the same as what Joe was talking about earlier in the webinar? I'm not too sure what the 5 wishes advanced directive is, but I thought maybe you guys might know.
I'm not familiar with that.
Neither am I.
All right. Well then, if you have more questions about that, I would suggest once again reaching out to Joe or Peter via email and maybe describe more in detail what it is that you're asking, and I'm sure they'll be able to help you. All right. So I want to thank everybody for joining us for today's webinar. I especially would like to thank Joe and Peter. You guys did an amazing job for such an informative session. Even the audience were typing in there saying that you guys did a great job. So just thank you. It meant a lot for you guys to come on today.
Thank you very much, and it was our pleasure. And of course, if anyone has any questions, you can feel free to reach out to us, and we'll do our best to help you.
All right, great. And thank you to the audience. And I also want to let you all know that you'll be receiving an email tomorrow, and in that email, you will get a recording of today's webinar. So if you want to rewatch it at any time, you can. And there will also be a survey in that email. So if you guys wouldn't mind taking it's like a 2-minute survey, just answer 10 questions, let us know how today's webinar went, and you'll also be able to suggest a future topic. So it's really helpful to us if you guys can fill out that survey. And just to let you know, we have another webinar coming up later on this month. On Thursday, June 25th, we will have a webinar on financial guidance for recent graduates. So I know it's a big deal, especially for our 2020 graduates who just went out into the world. They need a little bit of help getting their finances straight. It's a perfect webinar for that. So I'd like to thank you all again for joining us. Thank you to Joe and to Peter, and I look forward to seeing you all return to another webinar in the future.